When CPS removes a child from your home, the first court hearing happens fast. This hearing may be called a detention hearing, shelter care hearing, or initial removal hearing, depending on your state. But no matter what it's called, it is one of the most important days in your case, because this is where the judge decides one critical question. Should the child remain out of the home while the case continues? Many parents walk into this hearing unprepared. They assume the decision has already been made, but that is not how it's supposed to work. CPS must justify the removal. The agency must show that there was an immediate risk to the child and that keeping the child in the home was unsafe at that moment. The standard is usually whether there was imminent danger, not past concerns, not general worry, but immediate risk. Judges should ask, what exactly was the emergency? When did it happen? What made removal necessary instead of using a safety plan or supervision? At this stage, evidence may be limited. The court often relies on reports or testimony from the social worker, but that does not mean the agency's claims go unquestioned. Parents have the right to be heard. If you have safe relatives who can step in, this is the time to raise that issue. Relative placement is almost always preferred over foster care with strangers when safe and appropriate. Bring names, contact information, and any background details that support that placement. Another key issue at this first hearing is visitation. Visitation should begin immediately unless there is a safety reason to delay it. Courts should set a specific schedule, not leave it vague. Frequent visitation supports bonding and reunification from day one. This hearing also sets the tone for the entire case. The judge may ask about services, safety plans, or conditions that would allow the child to return home quickly. Parents should remain calm and respectful. Do not interrupt. Speak clearly when addressed. Your demeanor matters more than you think. If there were misunderstandings or incomplete facts in the report, this may be the first opportunity to correct them, usually through your attorney. Remember, this hearing is about temporary placement, not final judgment. The court is not deciding permanent custody yet, but what happens here can influence everything that follows. If removal continues, the judge must typically make findings about reasonable efforts, meaning whether CPS attempted to prevent removal before taking the child. If reasonable efforts were not made and the situation was not a true emergency, that matters. Parents should also understand that agreeing to certain temporary measures like drug testing, counseling, or safety conditions may help demonstrate cooperation early in the case. This is not about admitting guilt. It is about showing willingness to stabilize the situation. Documentation helps. If housing is stable, bring proof. If you are employed, bring verification. If you have completed prior services or maintained sobriety, that evidence may help. The first hearing is often emotional, but it is also strategic. Judges want to see whether there is a safe path forward. Can the child return home with supervision? Can a relative step in temporarily? Are there immediate steps that reduce risk? Those questions are central. The biggest mistake parents make is assuming they have no influence at this stage. You do. Preparation, organization, and respectful presentation can impact the court's decision, even in the early hours of a case. The system moves quickly at the beginning. What you say and what you document can shape the direction of the case. My name is Vincent W. Davis. I'm an attorney with almost 40 years of experience handling CPS cases. If your child has just been removed and you have a hearing coming up, call our law office at 888-888-6582. The first hearing matters, and preparation can make all the difference.